Gobble, gobble, gag, gag. We've been talking about gag orders on Black Friday because there have been filings in the various courthouses. We've been talking about gag orders earlier this week when it came to the oral argument in the D.C. Circuit Court of Appeals. That was a great oral argument to listen to. Hope everybody had the opportunity to watch that here on the Midas Touch Network. You had the Assistant Solicitor General from the New York Attorney General's office file an incredible brief with the appellate division, letting them know about all of the threats, actualized threats against Judge Engoron and his principal law clerk. Donald Trump continues, meanwhile, to file brief after brief in Washington, D.C.'s federal trial for his attempt to overthrow the results of the 2020 election. That case is set for trial in March of 2024. Trump is trying to do everything he can to derail that. An appeal was filed in the disqualification case in Colorado. Want to hear your take on that, Michael Popok. And then we go to the Eighth Circuit Court of Appeals, which made a horrific ruling regarding the Voting Rights Act of 1965. It was a 2-1 ruling that went against all Supreme Court precedent. But then again, with this current Supreme Court, do they even care about precedent? And does this right-wing MAGA Federalist Society judges across the country care about precedent? Unfortunately, I think not. But it is important that we understand what is happening here so we can confront it intelligibly and we can build something generationally to make sure that we protect our democracy now and forever. I'm Ben Meiselas, joined by Michael Popok. An abbreviated intro there because I really want to get right into it. And at some point in the show today, Popok, I want to also discuss, perhaps we do it at the end, all of the cases from the Manhattan District Attorney case, which not a lot of people are talking about, still criminal case against Donald Trump for his Stormy Daniel hush money payments. That's scheduled for March of 2024. The Washington, D.C. federal criminal case for Trump's attempt to overthrow the results of the 2020 election. That's scheduled for March 4th of 2024. The E. Jean Carroll's other civil defamation case set for January of 2024. The Mar-a-Lago document case set for, although we think it'll be moved, May of 2024. And then you've got a bunch of,
Rudy Giuliani's defamation case in December.
A lot going on. The wheels of justice turn in the right direction. Popok, how are you doing? How was your Thanksgiving?
My Thanksgiving was really fantastic. Not every holiday season do I have a fantastic holiday season, but for many good reasons. I've been blessed, and part of my blessing is to be a part of the Midas Touch Network and be your colleague and friend. And thank you for asking about that. I really like the rundown you put together for tonight. I think I usually do. It's a cross section. I think as we are about to turn the page on 2023 into a really important for justice 2024, I just think it's a very good audit of where justice is as it continues to bring people who did really bad things in 2020, in 2021, to justice. We said it would take a while. We asked people to be patient with us, knowing the justice system the way that you and I know it, and the court system. And now we're watching it. We're talking about trials. We're talking about potential convictions. We're talking about people who have already pled guilty and taken plea deals in the inner sanctum of Donald Trump and all of that. And I just think this is, and then we got to talk about the Supreme Court and its role in our society and how they are addressing things that matter to the disadvantaged, the disenfranchised, and just regular thinking human beings like the Voting Rights Act. So really hats off to your lineup for today.
When we talk about the Washington, D.C. federal criminal case against Donald Trump for his attempt to overthrow the results of the 2020 election, don't forget that the key witnesses, the star witnesses, if you will, against Donald Trump are going to be Republicans who worked for Donald Trump. Okay? As much as Donald Trump wants to say this is a liberal, deep state, blah, 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 the people who will be testifying are people like Mark Meadows, somebody who founded the Freedom Caucus. You don't get more right-wing and Republican, if that even has any meaning anymore, than Mark Meadows. Mark Meadows will be taking the stand. He's entered into an immunity deal that we've talked about here already on LegalAF, and we've reported before. And he's going to say, I committed crimes at the request of Donald Trump, who committed crimes. I want you to think about how powerful that's going to be. Then you're going to have the former Vice President Mike Pence testify against Donald Trump. Trump's VP is going to take the stand. How do we know this? Because these people have gone before the grand jury already. And he's going to say, yes, I believe what Donald Trump was doing was criminal. That's why I didn't go along with it. And then you're going to have Republican senior Republican officials in various states take the stand. And by the way, I tend to think that Bill Barr is going to be a witness as well. Not a lot of people have talked about that, but I think Bill Barr, Trump's AG, is a witness against Donald Trump. So it's going to look a lot like the January 6th committee in that the bulk of evidence is going to come from Republicans who worked for Donald Trump. Now, I'm not saying that at the outset of this episode just to be repetitive of other hot takes. That ties in to the gag order. Donald Trump knows what I just said. His lawyers have told him that. So what is Donald Trump doing to try to stop that from happening? And this is how you know he did it. Because if the facts, well, one, we saw it happen, but this is how you know somebody in general did it. If they're not arguing the facts and they're not arguing the law and they're attacking witnesses, they're attacking the judge, they're attacking the judge's law clerk, that's one of your big red flags that that person knows that if they don't derail this through threats and intimidation, that they are going to jail for a very, very long time. And you know, Glenn Kirshner was on the show with Michael Cohen, and I agree with Glenn Kirshner in the sense that I think that when Trump is convicted, when he is convicted, because I think he absolutely will be convicted, I think Judge Chutkan remands him into custody. I think he does go to prison and a deal's worked out with Secret Service where Donald Trump actually serves time in prison. Judge Chutkan is not going to cut Donald Trump slack, and Trump knows that. So what does he do? Attack Chutkan, attack the witnesses. And when we're talking about the gag order in the Washington, D.C. case imposed by Judge Chutkan, who were some of the people that Donald Trump was threatening? Pence, Meadows, Donald Trump's, the former chairman of the Joint Chiefs of Staff, General Milley. These are all people who worked with or for Donald Trump. I don't want that to be lost, but that I want to frame why we're even talking about gag order, the importance of it, because Trump is threatening them to try to intimidate them and prevent them from testifying, or hope that his minions go after these individuals and something happens. And Trump knows that when he posts, that's what his people do. He's well aware of that. So with that as background, Judge Chutkan entered a gag order, which of course we know. Oral argument, though, was held with the D.C. Circuit Court of Appeals in Popok. You tell us about this 3-judge panel, your observations from the appeal. Right now, the gag order has been temporarily lifted on an administrative basis, but what do we expect to happen next? Any surprises during this oral argument?
Before you leave Ben on the screen for a minute, this is going to be, look at us, black and white. We just tell it in black and white.
There you go.
No smoke or sunshine every week. You and I listened to the 2-hour oral argument on whether Judge Chutkan's decision, based on the facts that she reached as the trier of fact, and a trial judge like Chutkan is given tremendous discretion and tremendous amount of leeway to develop the facts. And she found in a series of filings and evidence that she took at an evidentiary hearing and oral argument that Donald Trump has made inappropriate, violent rhetoric attacks on different constituents of the criminal justice system, of which he is an involuntary participant. Involuntary because he is a defendant facing 4 felony convictions, serious ones, looking at 30 years, 20 years apiece for each of the conspiracies. And with that in mind, the First Amendment rights of somebody like that, and in every court that we're going to talk about today, at least the New York and the DC one, is struggling with the First Amendment rights limited of a criminal defendant and his lawyers within the court system, because they're not unlimited and unfettered. The lawyer for Donald Trump, this appellate lawyer, John Sauer, who, when he's not representing Donald Trump, he's a right-wing Federalist Society member who testifies before Congress in favor of MAGA and the weaponization of the federal government by the Biden administration. That John Sauer, his arguments was stitched together with references to things in constitutional law and First Amendment law that don't even apply. None of his case law applied to a criminal defendant or criminal lawyers in a criminal process. He likes to refer to concepts developed about the media, prior restraint, a doctrine that applies to members of the media and publishing companies who cannot be stopped, generally, from publishing information, even if it was obtained through a violation of the law under a concept we call prior restraint, has no place and no role in the analysis of whether Donald Trump can be gagged from using violent rhetoric to intimidate prosecutors, their families, their staff, and witnesses. None. He likes to talk about, in addition to prior restraint, clear and present danger, which is a great title for a lot of movies and books, but has no place in the analysis of whether a First Amendment right of a criminal defendant to attack other participants by name in the system. It's almost like he has constitutional Tourette's. He just spits out concept and phrases from some con law book that he read. He makes himself out to be a constitutional scholar, but not based on what I saw in the 2 hours of oral argument, 80 minutes of which was him dancing on hot coals, trying to answer, but not successfully, questions posed by the three-judge panel. The three-judge panel, Judge Millett, Judge Pillard, and Judge Garcia, is not a great draw for Donald Trump. I'll just say that. It's two Obama appointees and a Biden appointee, but it doesn't matter who appointed them. Their arguments on the Trump side just don't make any sense. And Judge Millett, who I think is going to ultimately be the judge to write the decision, and I think we're going to get that decision very quickly after a last flurry of filings on Thanksgiving Day by the Department of Justice and by Mr. Sauer in a one-page letter the next day. Briefing is now done, unless Donald Trump does something else despicable, and the Department of Justice has to call him out while we wait for the decision by the panel, which is what we call sub judice, or with the panel not yet decided. We'll get that decision, I think, early next week. I think Judge Millett writes it. And what she focused on, and she was the most hard-hitting of the questioners, the examiners for John Sauer, for Donald Trump. She said, what's missing from your argument, Mr. Sauer, is a balancing test. You're telling me that your client is above the law and has a First Amendment right to do and say whatever he pleases. But that's not what the law says. The law says we have to balance his First Amendment rights, whatever they are, and we determine them here, against the fair and proper administration of justice under the Sixth Amendment. And you don't seem to acknowledge that there's even a scale to be used by a court in balancing it. And she also said, and this is where I think we're going to see a little bit of a paring back, I want to get your view, of course, Ben, on this, of Judge Chutkan's order, when they re-gag him, and I believe they will re-gag Donald Trump, I think it'll be a little bit more pared back on some of the language than what is present in Judge Chutkan, because I heard Judge Millett say, we need to be surgical, like with a scalpel, to make sure that we balance properly these two competing interests. We acknowledge that he is the leading candidate for the Republican nomination. However, he's also a criminal defendant in a serious set of felony charges against him in a pending lawsuit. And so they have to be balanced. What is your... And John Sauer's like, basically, there's no balance. And you and I hit the nail on the head last week or the week before when we said, and I know I said it in a hot take, they're going to get him quickly wrapped around his own axle, his jurisprudential axle. When they asked John Sauer, I didn't know who the lawyer was going to be at the time. When they asked him, let me understand this. Do you agree with me? Your guy's not above the law. And they actually asked that question. He says, no, my First Amendment. He says, is your guy above the law? No. Okay, we agree on that. Secondly, do you believe that there's an ability for a judge to gag, to stop conduct short of a crime? because there's already criminal statutes on the books that address witness tampering and some other things. Is your position, I want to get the limits of your position, is your position that the only thing that a federal judge can do is only gag the things that are already crimes on the books? Well, and he couldn't answer it. And she says, you need to answer it. You're here asking me for relief. You need to be able to give me the limits of your argument. And then when he wouldn't do it, she gave it to him. She provided the limits, which is, I do not believe they're going to rule that the only conduct that can be addressed by a gag order by a federal judge is only that which reaches the level of a crime. Because why would you need to have the gag order then and the ability of a judge to control the decorum and the administration of justice? So the writing for me is on the wall. Sure, they gave it to Cecil Van Devender, who's the lawyer for the Department of Justice, and they wanted to test his position about the limited gag order, and can it be even more limited, and should it be even more limited? But I think they're working from the presumption, Ben, that I could see from the bench and the questions, that a gag order is appropriate in certain circumstances, even balancing the First Amendment rights of somebody. And where do you draw the line? And now they're going to figure out whether Judge Chutkan drew that imaginary line properly or not. I think they're going to carve it just a little bit back. And then there's two choices, and I want to get your view on this. They either do it themselves and blue pencil it. They pull out a pen and they say, well, she was right here, but then Chutkan, we're going to take this language of targeting people. We don't like targeting. We're going to erase it and we're going to call it something else. Are they going to blue pencil it, or are they going to send it back to Judge Chutkan for further evidentiary hearings to come up with another gag order? I want to hear your view. Do you think they re-gag in some fashion? Do you think they go all Chutkan, or do you think they surgically dial it back themselves or send it back to her for some repair?
I think they're going to remand it back to her to conform with the ultimate order, and they're going to provide the language which will look very, very similar to the existing gag order, but it will more precisely use the language from the Gentile case, which is a 1991 Supreme Court case. Then she will immediately utilize, I think, that language would be my prediction. And then, I mean, Donald Trump could then appeal that, but the precedent would already be set, so it would be a frivolous appeal. And then I think the Department of Justice, when they're opposing his appeal, if he tries to appeal the adoption and incorporation of the DC Circuit Court of Appeals language that they'll put in their order, it would be viewed as frivolous and kind of rejected out of hand right away. They're not going to say that there should not be a gag order and that Donald Trump can say whatever it is he wants to say, short of committing another crime. That's, I think you and I both agree, that is not something they're going to allow no gag order to exist. So they'll either allow the existing gag order, or they'll very modify it in a very simple way. During the oral argument, there was a lot of talk about a case, if you were listening to it, and you're not kind of enmeshed in all of the Supreme Court precedent on these issues, you may have heard them saying genteel over and over again. You may be saying, it's a nice word, but why are they saying genteel? Because there was a Supreme Court case in 1991 called Gentile versus the State Bar of Nevada, which tested the rules of professional responsibility in the state of Nevada, which limited the types of statements a criminal defense lawyer and their client could make in a criminal proceeding. And there, although the State Bar of Nevada's rules were ultimately found to run afoul to the constitutional test, the Supreme Court in 1991 found that the test for when a gag order can be imposed and when sanctions can be issued and what type of restraints can exist in a criminal case is whether there would be a substantial likelihood of material prejudice in a case, whether there was a substantial likelihood of material prejudice that would be caused by the conduct or speech of a criminal lawyer or a criminal defendant in a specific case. And so what the Department of Justice was arguing at the oral argument is, look, Judge Chutkan's standard clearly meets the substantial likelihood of material prejudice test because Judge Chutkan, went even narrower than that. She could have said substantial likelihood of material prejudice, but what Judge Chutkan said was significant and immediate risk to become targets. And so the language Chutkan used was slightly different, I think narrower and included within the broader substantial likelihood test. But that's where it really got into the weeds over language, Popok. And that's where I think that here the DC Circuit Court of Appeals is just going to make clear genteel is the standard. And this type of conduct would run afoul to genteel. And no, Donald Trump can't just say whatever he wants in a criminal proceeding. There's different level of restraints than outside of a situation when someone's charged with felony crimes.
So let me ask you about let me frame the submission that was made on Thanksgiving Day. Justice Never Sleeps, certainly the Department of Justice never sleeps, the one-page response, and get your view of what do you think the impact will be on the appellate panel as they're about to make their decision. So, and this segues a little bit later in our show tonight to what's going on with the gag order, as you said, gaggle, or whatever your comment was at the beginning of the podcast.
Gobble, goggle,
gaggle for the two gag orders, one in New York and one in DC, who have now, the worlds have collided, understandably so, because if you do bad things in one jurisdiction, it may come back to bite you in the backside in the other jurisdiction. Or as I said on a hot take, if you murder a man in Idaho, it may come back to haunt you when you're up for trial for murder in Ohio. And so you have a submission earlier in the week by the New York Attorney General, Letitia James's office, to the New York Court of Appeals, or at least the intermediary court, the first department over Manhattan issues, in which they submitted the affidavit of Captain Holland being the person responsible for the Department of Public Safety Judicial Threat Assessment Bureau, thank God that exists, to protect judges and staff from being assassinated, attacked, and stalked and things like that in New York. And I assume every court has a version of that. Captain Holland put in an affidavit, a declaration, in which he outlined all of the credible threats that have increased against the principal law clerk for Judge Engoron, who's been mercilessly and improperly attacked by the lawyers for Donald Trump and Donald Trump himself. I mean, hundreds a day, Ben. So many attacks, anti-Semitic, misogynist, threats of bodily harm, threats of assassination, body shaming, you name it, 50, 80 a day email. They cracked or they hacked into her computer, into her cell phone, voicemail messages, and everything else. So much so that it comprises, as of earlier in the week, 275 single-spaced pages of transcripts for all of these merciless attacks on her. On the judge side, they said, we're not going to tell you how the judge was attacked because we don't reveal that. But let's just say the judge had a number of credible attacks on him that I won't reveal in this particular affidavit. The Department of Justice saw that, couldn't ignore it. It went to issues that came up not only during the oral argument, but also in the briefing between the parties, because Donald Trump couldn't help himself from bragging that they got one justice, and we'll talk about it more in the next segment, one justice on an administrative interim basis to agree to a temporary stay order of the gag in New York while the full appellate court made a decision. Same thing that the DC appellate court did. Exactly. Same thing that Chutkan did in staying her own order. It's not amazing to do that. And it doesn't mean you're going to win on the merits. But of course, a justice of the appellate division stayed the gag order in New York. Well, you just opened the door to the gag order in New York issue. And so when this new bombshell affidavit got filed, the Department of Justice said, well, here's some supplemental authority you might want to chew on while you're deciding the issue. Panel, 3-judge panel in District of Columbia. Here's what just got filed about Judge threats, to assassinate judges and law clerks in New York by the same guy and the same attorneys. Take a look. And then if there was a stupid response by, and you can talk about it, of course, by John Sauer, a one-page, he must have been in between Thanksgiving, one page, that's it, submission, because he wanted to try to get the last word in. Panel has it, obviously. What do you think the impact is of this, Captain Holland affidavit on the panel in the District of Columbia?
Look, it's powerful. I don't think it really makes a difference for where the panel was going anyway. I think that they recognized the totality of circumstances here, that when Trump does X, Y happens, and they recognize that through the oral argument that there was real conduct that would follow when Donald Trump made these posts. Look, I think adding a mountain of evidence of additional death threats certainly bolsters the view and perspective that there needs to be a gag order in some form imposed. But, ultimately, I don't think it's going to change where the panel was going anyway. I want to talk about that. I also want to talk about what I just said, though, the totality of circumstances here, because what Donald Trump relies on is the vagueness and ambiguity in how he makes the threat. And that's why people have said, including Michael Cohen, and we've said here, that Donald Trump speaks like a mafia boss. He doesn't say, I want you to do this to this person. He just says it would be unfortunate if something happened to this person. And then it is clear to his followers what he is asking them to do, and then they do it. And then he goes out in his various speeches and, for example, mocks Nancy Pelosi's husband, who's the victim of attempted murder of somebody who was convicted for the crime, and then mocks that and laughs at it and jokes about it, thereby encouraging other cells, basically, there's no other way to describe it, to engage in that behavior. Let's talk about that and more. Let's talk about what's going on. We'll flesh it out in a little more detail in the New York Attorney General civil fraud case, and how ridiculous it is that you're even in a case involving financial valuations where these people can't even control themselves. Donald Trump and Trump's lawyers in a case like this. We'll talk about that and more after this quick break.
If you're like me, morning coffee, non-negotiable. But I was tired of either waiting in line for an overpriced cup or settling for gritty, bitter coffee at home. Now I've switched to using AeroPress, and I'm never going back. It's so easy and convenient and incredibly unique. I never knew coffee at home could taste this good. AeroPress is like a French press, only better. It's the only press that uses a patented 3-in-1 brew technology, combining the best of several brew methods into one portable device for a completely unique and delicious flavor profile. Smooth, rich, and full-bodied, without the bitterness and grit found in other presses. And as a bonus, AeroPress can brew thousands of recipes. AeroPress travels better than others too. It's compact and incredibly durable. That means you'll never have to endure terrible coffee at the hotel, on the job, or on an adventure again. It brews and cleans in less than 2 minutes. Just add medium fine coffee grounds, pour in hot water, stir for 5 seconds, brew for 30 seconds, then press into your favorite mug and enjoy. There's a reason why AeroPress is the barista's favorite home brewing tool. AeroPress is the best reviewed coffee press on the planet, with more than 55,000 five-star reviews. Thoughtful, proven, and under $50, AeroPress is the perfect gift or stocking stuffer for every coffee lover in your life this holiday season. Don't settle for less than the best. They'll love it. AeroPress is shockingly affordable, less than $50, and we've got an incredible offer for our audience. Visit aeropress.com/legalaf. That's AEROPRESS.com/legalaf to save up to 20%. That's aeropress.com/legalaf to save up to 20%. It's time to ditch the drive-thru, toss the French press, and say yes to better mornings fueled by better coffee. AeroPress ships to the USA and over 60 countries around the world, and we thank AeroPress for sponsoring our show. Finding the perfect gift can be really hard sometimes. That's why I like Aura frames. Named the #1 best digital frame by Wirecutter, They're an easy, thoughtful gift to get your loved ones. Every year, I always have trouble shopping for my family, for my mom, my wife, her family abroad. It can be hard to find them the right holiday presents. Aura Frames is perfect for them because it's amazingly versatile and allows them to display all of their favorite photos and memories. The Aura Frame is super high quality, and it's amazing to see all of these photos cycled throughout the day. Instead of spending hours at the store, I'm now spending hours picking out photos to share. You can upload as many pictures as you want before and after it's shipped out from anywhere, and you don't have to agonize over choosing the one perfect photo. There's unlimited storage, and grandpa or mom or whoever can swipe the top of the frame to see everything and pick their favorites as well. Make holiday shopping easier than ever this year and give a thoughtful gift they'll love. From now through Black Friday and Cyber Monday, Aura is having their best deal of the year. So listeners can save $40 on their best-selling Carver matte frame by visiting auraframes.com/LegalAF. That's AURA frames.com/LegalAF. Use promo code LegalAF to get $40 off their best-selling frames. Terms and conditions apply.
Welcome back to Legal AF. Michael Popok, Ben Meiselas. But before going back into speaking on the gag order in the New York Attorney General civil fraud case and how the filing before the appellate division was used in the Washington, D.C. appeal in the federal case of the gag order there, it's just worth noting for a second, Popok, you've practiced for over close to 30 years, and you practiced in that courthouse in New York where Judge Engoron sits. You've done a lot of civil cases, in that specific courthouse. And the very fact that litigants go in there every single day and have very serious disagreements with each other. These are parties that detest each other, suing each other, family rivalries, people who, corporate companies that hate other people. You got employees suing companies for serious misconduct. You've got all of this stuff going on in this civil division that's in New York. And you don't hear about this unprofessional and just disgusting behavior. And you've got people who are always fed up on, usually with the way a judge rules, or if Engoron ruled for the other side. Happens every single day, hundreds of times a day, thousands to tens of thousands of times a year in that courthouse. But our whole system is based on this good faith in the process, in the system, in the judiciary. And what Donald Trump has done his entire life is anything that relies on good faith, right? Whether it's contracts, whether it's our social contract that is our Constitution, whether it is the unspoken rules that allow our courts to have the legitimacy. That's where lots of people looked at our system and was like, how are you? You just go along with good faith? And Trump and this MAGA movement came along and they were like, nope, we're ripping it apart. We don't care what it says. We don't care what the contract says. We don't care what the Constitution says. We're going to attack you and you and you. We're going after all of you. And that's just something that our system actually struggles to contain. And so while there was just this administrative stay of the gag order that's now subject to this appeal in an Article 78 proceeding in New York, which is where that affirmation by the public safety officer and the Solicitor General's filing talking about all the threats to Judge Engoron and Judge Engoron's clerk, all of that was filed. But like even the appeals court now, the appellate division has to really kind of struggle with the fact that, well, we have the First Amendment, which says Donald Trump can post a photo, and he's just posting a photo of the law clerk. And so without getting the 275-page single-spaced affirmation and learning about the totality of circumstances of how Donald Trump operates, you can see a judge or a justice sitting in an appellate level saying, but what's the issue here? until they get the voluminous filing of this is causing copious threats every single day. And that's what Trump and this MAGA movement's doing to our judicial system. And that is where, you know, the judge, when he first made the order lifting the gag order on an administrative basis, doesn't have that record. He just like, I just see a photo. What's the issue of Trump posting a photo? The issue is the modus operandi here of what's happening.
Yeah, and I liked that a lot. The social contract is really, really important to me. I operate in a certain way, and so do you, because we were raised with morals and values, and I entered a sacred oath as an attorney to uphold, as an officer of the court, the ethics and to make sure that there's the fair administration of justice from my end. There's a reason I don't wear my pajamas or a smoking jacket into court and ask the person in the black robe to move over because I've decided to sit on the bench today. I guess I could do that. It would be a one-shot deal, and then I'd be asked to go meet the bailiff with my toothbrush. But I would never think to do this. I've did the math while you were doing some of your rundown there. I think I've appeared in front of over 125 judges and arbitrators in my career. I've never seen what's happened with Donald Trump in my entire career, except once. One, and I won't name the person or the matter, but in an arbitration, my opponent decided at the beginning of the trial to use his beginning minutes of his opening statement to completely bash the arbitrator, calling him incompetent and prejudiced and not fair and balanced and not impartial and never having ruled in favor of a person like his client before in his entire, this guy was in his 70s. He was almost a semi-retired lawyer at that point. And I sat back, because I knew this lawyer, and I sat back thinking, this is either genius or insanity, and I'm not sure what I'm watching yet. I was like, I almost had to like muffle a smile because I knew this was going to backfire, and it did. He didn't win at all, and there's a reason you don't do these things. I have not agreed with every judge I've been in front of. I've been frustrated in front of some judges. It's been reported in the media that I've been frustrated with some judges during trials where I sort of put my head in my hands and the media caught it, but I would never cross the line to be abusive to the judge, the staff, a clerk, a court reporter, a sheriff, a deputy sheriff, an investigator, an FBI agent, or anybody like that. If I can't win my case in terms of my advocacy and being respectful and being a part of the social contract, then I don't want to win my case. And I don't want to be a part of that profession. Soon, these lawyers that are doing these things in the civil case, I think that's your point you're making too. This isn't even about Donald Trump going to jail. This is about Donald Trump stroking a check, and his lawyers are acting this way. And these lawyers may not be acting this way for much longer. As I said on one of my hot takes, first of all, they're the third string for Donald Trump, which is pretty low. Varsity already got fired, lost their bar licenses, or are indicted or now convicted, pled guilty. Junior varsity, same thing. I don't even know what this is. The scrub team, and all they're doing is risking their bar license for what purpose? To make the extra buck, so they can go to that MME fighting thing with Donald. They just love being in the company of Donald. It's so weird. I've never seen it before. This conflation between the lawyer and his client. I get that Chris Keiss has no other clients. I mean, he just went out and left a law firm to represent Donald Trump. I'm sure he hasn't been out pounding the pavement to get new clients lately. And Todd Blanche, the same thing. He left his law firm to represent Donald Trump. I haven't seen him represent one other person since then. So I get it. And Alina Habba had some little tiny firm, and you did a great hot take about she and her husband own millions of dollars in tax liens because they don't pay their taxes. I mean, that's a perfect lawyer for Donald Trump. In the courtroom itself, they are losing. And you and I and Karen have done hot take after hot take in LegalAF episode after LegalAF episode for the 7 weeks the trial's been going on in the civil fraud case. They are, here's a newsflash for those that are crossing over to watch us as part of our audience. Donald Trump is losing his civil fraud case badly, not just because of the witnesses that the Attorney General put on in her case, but because of the witnesses Donald Trump has put on in his own case. The evidence is strongly against Donald Trump to prove that his company wasn't just a fraudulent house of cards for all of this time, in which he was able to borrow money he wasn't entitled to, get loan approvals he wasn't entitled to, get insurance he wasn't entitled to, get permits and deals approved that he wasn't entitled to during that period when he was a mere billionaire and not a triple billionaire. And that's what this whole case is about. They are going to lose. And when they get one little victory, like, oh, Justice David Friedman, he said no gag order for 2 weeks. Then they go out and completely try to, cause credible bodily harm to the law clerk and to the judge in the interim, hoping that no one else will notice. John Sauer says in his filing in the District of Columbia, an irrelevant set of facts about what's going on in New York, an irrelevant set of facts, a judge being subject to an assassination attempt because of comments made by Donald Trump when he wasn't gagged. That is the height of relevancy. And so the thing that we're watching, then we can segue into the New York Attorney General thing. I'll set it up and turn it back to you. So you've got the gag order in New York is even more limited than the one that Tanya Chuck and Judge Chutkan issued for Donald Trump. In the DC one, it's don't use violent rhetoric against these participants in the criminal justice system and don't target them. In Chutkan and Goron, in the New York civil fraud case, it's even more limited. It's very specific. Stop attacking my staff and my law clerk. That's it. They can't even pull that off. That shows you how dastardly and despicable they are as lawyers. They can't even stop attacking the poor defenseless law clerk who's a member of the New York bar, I'd like to remind them, and could be a future judge that they'll have to all appear in front of one day. They're bashing her mercilessly, causing potentially bodily and grievous harm to her and the judge as well during this period, because they're losing in the courtroom. And this one judge, Judge Friedman, I'll leave it on this, turn it back to you. Judge Friedman is the same judge that temporarily, administratively, interimly stayed the trial before the trial even began on a request by Donald Trump. But by the time the full panel of the appellate division, of which he joined, 4 other people, they totally vacated his order and ruled against him and let the trial go forward. So just because they got David Friedman in a 1-hour hearing without the benefit of Captain Holland's affidavit about all of the bad things that have gone wrong and the increased threat assessment that has happened to these members of the judiciary and their staff, it was not in front of him. They didn't have any evidence in front of them. They had whatever the gag order was and whatever the lawyers on their feet could come up with on an emergency hearing that was called at the last minute down at the appellate division courthouse. That's all they had. With full briefing, I would be shocked if this appellate division wants to send the message to this Donald Trump or future Donald Trumps that you are free to abuse our judges and law clerks, and we won't do a darn thing about it. What do you think will happen, Ben, if that's the message that's sent about the court system in New York?
You will have a full revolt of all of the trial judges.
Right.
It's not just Judge Engoron. You have all of the trial judges in New York watching this. And they're thinking to themselves, if you allow lawyers to go against what the judge is saying in the court, you are going to destroy, as I said before, that social contract that exists, but more narrowly, the rules that govern just the basic decorum and functioning of a courtroom. And you're going to make all of our judges, trial judges, targets of death threats. The message you're going to send is all litigants can cite your opinion, judge, and can say, look at what Judge Friedman said. Judge Friedman says attacks are okay on trial judges. Go for it. And that will be cited as precedent for that. That's why one of the things that I thought was very powerful that Judge Engoron actually did in opposing this temporary lifting of the gag order is that Engoron actually got involved in the opposition. and you had people on behalf of Engoron going through the threats that Engoron faces, that his law clerk faces every single day. Because that the public safety officer talking about the death threats, to your point before, Popok, the 275 pages, single space that listed all of the threats that have taken place since October 3rd, basically, caused by Donald Trump and Trump's lawyers' behavior, and says, okay, appellate division, here's the record. If you're going to say this is okay, you're going to single-handedly destroy the ability of trial judges to conduct business in the state of New York. David Friedman was appointed to the appellate division back in 1999 by a Republican New York governor, George Pataki. Again, what he did was administrative, but and it's not like a full lifting of the gag order. But as I've said before in some of the hot takes, you could see a scenario where an appellate judge, an appeals judge, gets this record before them and goes, well, what's wrong? It's just a photo. It's just this. It's just that. But that's why here in Goron, the court staff, the public safety officers made sure to give this full record of all of the death threats that have happened. So we'll keep you posted on what happens there. But I want to, before going on to the next topic, Popok, I want to go back to again, why is Donald Trump engaged in this behavior? And to your point, I mean, setting aside the fact that he's a maniac and he is he engages in this behavior, and that's just the stochastic terrorism that he and his movement do every single day. They're losing. Donald Trump's former controller testified earlier in the week. Jeff McConney testified. McConney broke down, started crying during the examination, may have hinted at the fact that there's another criminal case that's being investigated out of the Southern District of New York when he was listing the various proceedings that he's involved in while he's breaking down and while he's crying. No one had realized that there's some Southern District of New York federal criminal investigation apparently going on. There was no follow-up, so no one really knows anything more than that. I asked Cohen on Beatdown. Cohen didn't know what McConney was talking about there. But one of the things McConney said during the cross-examination was that he was given these numbers. The numbers were inaccurate. During the cross-exam, it showed that all of the approvals, that Donald Trump was the one responsible for giving all of the approvals on all of these financials. And McConney's testimony is devastating for the Trump organization. This is a document case. The documents show that Donald Trump engaged in the fraud that he's being accused of. It doesn't mean that Mar-a-Lago is not a valuable property, or 40 Wall Street, or the triplex, or Bedminster. It doesn't mean they're not valuable properties. It just means the way Trump manipulated the properties on paper were fraudulent. It's undisputed. Sure, Mar-a-Lago as a residential property, you want to say it's valued at $250 million. Certainly not $1.5 billion. You want to say it's $250 million? Sure, if it's a residential property, it's not. Why? Donald Trump wanted to pay less property taxes. So he encumbered the property with historical easements and a deed which says that it's forever going to be used as a commercial property, as a club. It's not a residential property. So the Trump organization devalued the property at $27 million, not Judge Engoron. The triplex, not 30,000 square feet, is 10,000 square feet. It's still impressive. You got a triplex in New York. Who's triplexes in New York that are 10,000 square feet?
You don't have yours anymore, do you?
No, I don't. But he lies about everything is just, on paper a lie. And that's why they're attacking the clerk. That's why they're going after that. But what's extra frustrating Trump, though, right now, is that he thinks these tactics, because they've always worked in the past.
That's right.
He's bullied people his whole life into submission. And by the way, when he's put that golden spoon money that he was born with, and you use it to bully people, you can see he's bullying some of the most powerful people right now in the, whether it's special counsel Jack Smith, the judges. Imagine when he uses that to bully the contractors or to just bully someone else in a deal. That's how he ran over people his entire life with these tactics. And this is the first time that our democracy is facing this stress test, and our democracy is saying no. And so he's pushing against that. And we just haven't seen anything like this before, Popok,
Yeah, and a couple of comments just to drill down on McConney. You're so right about this being a document case at the end of the day, and And it will be Donald Trump's own words. And the handwriting is not on the wall, as I said on a hot take. It's on the documents. It's in blue ink, and it belongs to Jeff McConney, also known as the spreadsheet czar, who he's the one that wrote all over the financial statements before they were sent out to the lenders with commentary and comments and questions for Donald Trump to answer. For instance, hey boss, should we put on your financial statement deals that aren't yet closed but are only in the pipeline, like forecasted deals? That'd be like you and me driving by a house saying, let's put that house. I like that house. Let's put that house on my balance sheet. I like that house. I don't own it, but put it on my balance sheet. I like it. And then, of course, Donald Trump at the top, it says for DJT review, which totally blows the doors off of Donald Trump's arguments. Like, I wasn't really involved. See, this is the tension. Their argument has always been on the Trump side. It wasn't me. If it was anybody, it was Meiselas, the outside auditors. And here you have Jeff McConney having to testify to admit that his handwriting is all over the documents, that document ultimately went to Donald Trump himself or Eric Trump when Donald Trump was in the White House. And when he was giving his direct examination responses to Trump's lawyers in a friendly way, which is when he broke down and cried, by the way. He broke down during the direct examination led by the Trump lawyers, not by the cross-examining attorney general. We'll leave that for a minute. He said, oh, here's the process. Statement of financial condition, I drafted it. I gave it to Alan Weisselberg, the longtime non-certified public accountant, chief financial officer for the Trump organization, who's gone to jail. And then we gave it to Meiselas, the outside auditors, and then they looked at it and verified it, and they hit print. And then he had to admit under cross-examination, didn't you leave out a step, sir? Didn't you leave out the step where it goes to Donald J. Trump or Eric Trump for approval of the numbers in there that are inflated by $300 million? Did you leave that out? Isn't that your handwriting? Yes. Didn't that go to Donald J. Trump? Yes. Didn't that go to Eric Trump after that? Yes. We keep saying a lot of things are bombshell and devastating. This is really bad for them. That is the first witness who has said that Donald J. Trump was involved with the financial statements that are fraudulent. And again, you're right. We keep reminding people, we're not saying the guy wasn't a billionaire. The problem is he needed to be a 2.5 billionaire for the Deutsche Bank set of loans, and he needed to have $500 million worth of free cash, liquid cash, and he didn't. So he made the numbers up. It's like I said, and I said to somebody recently, I can have a piece of property and I can have it insured, but if I burn down the property to get the insurance, that's the fraud. We're not saying he didn't have any assets. I love all the Trumpers. Like, he's a very successful. By the way, he wasn't that successful. $1 billion is a lot of money, but not a lot of money in the world of finance or real estate. Okay. And so it wasn't enough for him. He didn't want to be able to just borrow X amount. He wanted to borrow 3 times X amount. And the only way he could do that was to lie. And that is the entire heart of the case. He's going to lose, not because Judge Engoron was democratically voted in, or the law clerk went to a Chuck Schumer fundraiser, or because they don't like the color of the tie, they're going to lose because they committed fraud over a number of years, and the documents and witnesses support it. And we're not here even on the criminal standard of beyond a reasonable doubt. This just has to be preponderance of the evidence, meaning the scale just has to tip. When you line up the evidence for and against, it just has to tip ever so slightly towards the New York Attorney General's case. It's overwhelming evidence right now, but it just has to tip ever so slightly, and then you lose your businesses and your money and your buildings and the names on buildings and everything else. You can go cry about it all you want on the courthouse steps or in your rallies or raising your fundraising money, but it's not going to change the reality. And then when he loses by Judge Engoron, and he's going to lose from Judge Engoron sometime in December, early January, I said maybe when they're picking the jury in the E. Jean Carroll case will be right around the time the order comes out. Then they'll have to take an appeal to the New York Appellate Division First Department again, with another judge panel, another 5-judge panel there, and then they're going to lose there. And then they're going to go to the Court of Appeals of New York. And that is the last stop, not the U.S. Supreme Court, the Court of Appeals for New York. And all along the way, he's going to lose. He's just trying to hope he loses after the election, not before the election.
Popok, you worked at a large Wall Street company that actually earns billions of dollars in revenue, that actually has a lot of employees and executives. Could you imagine any scenario ever, just based on your past experience, where the head of the organization, where the CEO, the COO, the co-CEOs would ever basically say, we don't look at our financials. We just relied on the professionals and it was their fault. We don't even look at those things. We're too busy pouring concrete. You're the perfect person to ask that question based on your experience being the number two. Could you even fathom that as something that is happening?
Let me tell you how it worked. The chief financial officer for my boss, who was the Donald Trump of that organization, but with real money and assets behind him, his office was intentionally 12 feet away from the chief financial officer's office. He was in that office along with the general counsel and people like me on a regular basis to find out how much money they had. What did the unaudited financial look like? How much lending power did we have? You know how many times he made a phone call to the outside auditors? Never. The outside auditors came in regularly. I met with them on a regular basis on the litigation side of the house. But when they came in, that's not, you don't run your business based on audited, the auditor, first of all, is only sampling your financial statement. They're not looking at every transaction. That's why it's called an audit and not I don't know what. You don't call hey, Mr. Auditor over at, Big Five auditing firm. Hey, I want to go for $100 million loan. Do I have the money? That's not who you make the phone call to. You walk down the hall to your chief financial officer who knows all the banks and all the lending and knows what the stock is up or the stock is down, the asset values, and says, yeah, you can go for that. Or we can arrange it with this kind of borrowing or we'll float a bond or we'll go to the market in this way. There was never a conversation between my boss and the outside auditors, except when the outside auditors needed to interview him in order to make sure that the audited financials were on the up and up. That's it.
Or how about the Trump organization's chief financial officer does not know, this is what he said under oath, what generally accepting accounting principles are, yet alone getting in the weeds of it, but just doesn't know generally what GAAP even is as the CFO, who's not a CPA? Like,
you couldn't hire that. First of all, my company would not and could not hire somebody in a control. These are control positions. We talk about them a lot. And that means what it sounds like. There are controls within an organization to make sure that systemic fraud is not going on inside. Okay, controls in the accounting department, controls in finance, controls employment rules and regulations. And there are control officers that are responsible. There's the head of compliance usually for an organization. You know what's missing at the Trump organization? A head of compliance. I don't know who it is because there isn't one. But most organizations in New York or in Delaware and other places have a head of compliance, making sure that laws and regulations in the various industries that you operate in are being complied with. You have the internal audit, which is responsible for catching fraud in the company before it goes up to the external auditor. I've never heard of an internal auditor at Trump organization because he doesn't want one. He doesn't have one. Okay, you have the controller who reports to the chief financial officer, who is usually a certified public accountant and comes out of a Big Five accounting firm or whatever the number's up to these days, because they need to interface with their counterpart at the outside auditor like Meiselas, and they got to talk in a language that makes sense. Meiselas obviously realized that nobody over the Trump organization, intentionally by Trump, was qualified to be in a control officer position. How they certified those audits year after year until after 12 years, they said we can't do it any longer and everything we wrote in our certification is wrong. How they even would take that engagement, knowing let me put it this way. If I were a major accounting firm, auditing firm, and I was being asked to audit for purposes of lending, banking relationships, and the like, an organization that had these people handpicked by Donald Trump to be in control officer positions, I would tell them in the first audit, if I took the engagement, or even prior to that, in taking the engagement, we cannot take the engagement until you improve your control officer positions by placing in those positions these kind of people with these kind of credentials. And you're missing a compliance officer, you're missing an internal audit person. And until you have that structure, we won't even do your audit. If they have the balls to do that, that would be what I would do. If they take the audit and realize these people are not qualified, then in the notes, they should say, Alan Weisselberg is not qualified for his position, and neither is Jeff McConney. But this is what I'm saying when people say Donald Trump is this great business person. He's not. He handpicked people, many of which had his last name, and put them in positions they were neither qualified to occupy nor had any desire to implement any of the appropriate control officer positions. And why do you have a weak set of controls in a company? You're going to know the answer to this, Ben. You know where this is going. Why do you fashion a company that has weak control officers and weak or no controls? It's because your company is based on fraud. When you're running a fraud company, you want to make sure everybody is asleep at the switch.
Yeah, and then he has a shell game of the actual assets where you're taking from Peter to pay Paul and taking from Paul to pay whoever, and you run that over and over and over again. And then if you're able to pay back Paul after taking it from Peter, you go, but Peter wasn't damaged. He got paid back, and you hope that the value of the real estate continues to go up. And meanwhile, you've gotten an unfair advantage from everybody else out there who's playing by a set of rules, who's playing by the social contract called the law, where we in the United States say nobody should be above the law. And I thought it was such a perfect way, Popok, to get your unique expertise in this area, because all of these people who want to MAGA-splain, well, this is actually a very successful, this is how it's run. It is always the case. No, it isn't. It is not. Stop it. We're not saying that Mar-a-Lago's not valuable. We're not saying that, okay, you have a 10,000 square foot triplex. I mean, why a MAGA person who is struggling to get by, and with Donald Trump putting $8 trillion in debt into our, why you are so proud of Donald Trump inheriting a lot of money from his daddy, and he's okay, well, you live vicariously, whatever it is. We're not saying that that's not, it's big, okay? 10,000 square foot triplex. Good work. I don't know what I'm going to say to you. That's impressive, I guess, if you live a materialistic life, which is ridiculous. But if that impresses you, fantastic. But the bottom line, it ain't 30,000 square feet. Mar-a-Lago ain't a residential property. And he does that with each and every one of his properties. But Popok, thank you for clarifying that. When we come back, I want to talk about this Eighth Circuit Court of Appeals opinion gutting the Voting Rights Act and what we think is going to happen there, especially after the recent Supreme Court decisions where it seemed to directly contradict that, but that won't get in the way of a right-wing MAGA appeals panel. Also want to talk briefly about some of the reply papers that Donald Trump's been filing in the Washington, D.C. case. That and more. Let's take a quick break.
It's time for a word from our show's sponsor, Highland Titles. Highland Titles sell a unique gift with a legal twist. In the Land Registration Act of 1979, lawmakers in Scotland legally defined a souvenir plot of land. This is a plot of land so small, most often 1 square foot, that its value is solely commemorative or sentimental. So you can buy a square foot of Scotland for just $30. Why do people do that? Well, Scottish landowners were traditionally given the courtesy title of laird. The English translation is lord, and the female equivalent title is lady. Buying a plot of land from HighlandTitles.com will enable you to legitimately style yourself as a lord or lady of the Glen. You get a legal right to a plot of land you can visit anytime, and a luxury gift pack too. The gift is so good they made it legal. Check it out at HighlandTitles.com and use the discount code LegalAF to receive a generous 50% savings. This discount code can be used from today until the end of Black Friday. That's HighlandTitles.com, promo code LegalAF.
Welcome back right now to Legal AF. Great to have everybody here again. Hope everybody had a wonderful Thanksgiving. Hopefully you're having a relaxing weekend. I want to talk, Popok, very briefly about these reply briefs that Donald Trump filed. He filed a bunch of motions to dismiss, as we've just explained, strategically, rather than filing one motion to dismiss is what you would normally do, and then have different headers with the different arguments that you would make. If you're claiming, vindictive or selective prosecution, if you're claiming presidential immunity, if you're claiming statutory and constitutional immunity, and those would be arguments. Donald Trump's strategy, though, is to trifurcate, make multiple motions, and then try to appeal them all and hopefully get in front of a DC Circuit Court of Appeals panel that will stay the case from going forward in March. That's the whole game, because these motions are so incredibly frivolous and the replies are even more frivolous. I mean, I was reading this one that Donald Trump filed, a reply on the vindictive and selective prosecution motion, where Donald Trump is arguing that the plot to vindictively, selectively go after him, he goes, began in 2020 under Bill Barr. So he brings Bill Barr into it as though Bill Barr's responsible and his own Justice Department's responsible, dating back to December of 2020. But what Donald Trump's doing, when you actually look at the vindictive and selective prosecution motion, after spending a lot of these pages whining, what Donald Trump tries to do is say, but I should be entitled to discovery so I can then prove my vindictive selective prosecution, and then discovery will take time. And that's his way of trying to delay this thing, and by saying I'm entitled to all this discovery. Now, when you look at what the discovery he's claiming that he's entitled to in order to try to prove up a vindictive or selective prosecution motion, he's like, produce to me all of our national security documents regarding the intel on Russia's interference in our elections, and Iran's interference, and China's interference with our elections. And as I did a hot take on, seems like it's kind of quintessential gray mail, whereby a criminal defendant basically says, I want these documents, I want to make them part of the public case, even if it jeopardizes our national security, unless you dismiss claims against me. And look, Judge Chutkan's going to see it for what it is. Unlike Judge Cannon in the Southern District of Florida, this is going nowhere. But Trump's attempt at filing all of these different motions to dismiss, and he filed the multiple replies. Judge Chutkan gave him a brief opportunity for a few extra days extension, so he filed all of these replies to the motion to dismiss. What I think Judge Chutkan's going to do, and I want to hear your take on some of Donald Trump's reply briefs, I could be wrong on this, but I think she's going to try to consolidate her opinion into either one or two orders, which she's already been, I think, working on, because she knows how baseless it is. And whereas Donald Trump tried to divide, I think she'll try to have an omnibus order addressing them as one. So if Donald Trump files an appeal, it's one appealable order versus kind of multiple, which is what Trump was trying to do. You saw Special Counsel Jack Smith in his opposition, I think very intelligently tried to do an omnibus with some of Donald Trump's motions to dismiss, but those aren't going anywhere. They're beyond frivolous. And again, Donald Trump's not arguing, I didn't do it. Right? His arguments are, former president can do anything they want to do. You're selectively going after me. I want you to remove allegations from the indictment that reference my connections with January 6th insurrectionists. And there's nothing that a former president should be restricted from doing or saying or any, and it's, I have a First Amendment right to engage in this behavior, not the behavior that I engage in. What are you talking about? The behavior was fine. He never argues that. The same way in New York. I don't think he'll take the stand again in New York. You don't hear him on his testimony in New York when he took the stand going, look, I'm super diligent here. I go through the financials. We have meetings once a day. I meet with the CFO. I confirm their accuracy. The New York Attorney General's off because if you go to, let's turn on to the spreadsheet page 365, take a look at over here. I make sure that we have these controls, and this is why it's accurate, right? Donald Trump in DC is not arguing what I did. He's not arguing I didn't do it. He's just saying I should do whatever I want to do, and you're specifically targeting me. Well, you did it. You're being prosecuted because you engaged in the crimes. What did you make of his filings, Popok?
Yeah, I think I think that's a good overview. They're going to, let me start with how you started it. He's going to lose all these motions to dismiss in front of Judge Chutkan. We thought so on the first brief, the opening brief, and certainly now on what they're trying to masquerade as some sort of reply that is no better than their opening brief on these issues. She's already ruled in one order that references to Jan 6th should stay in the case appropriately in the indictment for many, many good reasons. That was one of his motions. So he's already 0-1. I thought the argument that he's raised in his most recent filing, that there is nothing in the indictment that is anything other than a criminalizing of First Amendment speech with no conduct attached to it, is just a bald-faced lie. They argued in their most recent brief that the indictment should be dismissed because all it's doing is criminalizing First Amendment speech, and there's not one example of conduct. Well, I did a hot take that's up, I think, right now, where I outline all the paragraphs of the indictment, because I think it's important, and I read from them, including in paragraph 10 and all the subparts there, in which it's alleged that Donald Trump, working with the 5 or 6 unindicted co-conspirators, hand in glove, did a bunch of things, conduct, and in doing so, violated conspiracy statutes on a criminal basis. The fact that you use your voice to facilitate the conduct doesn't mean you have a First Amendment right to do that. I mean, people don't rob a bank together using mental telepathy or hand signals. They rob a bank together because they've had conversations about it, and then they implement it, and they give instructions along the way. Okay, that is the crime. The crime is not him being able to say, I think I won the election. In fact, in paragraph 3 of the indictment, Jack Smith says point blank, we are not here to criminalize his First Amendment right to object to the results and to say that he won when he lost. It's when he takes it the next step and uses that to create election interference by way of conduct. It's the pressuring of the election and elected officials to get them to do his bidding, to find votes for him, to go down fraud trails when he knew or shouldn't know that there wasn't any, to delay the peaceful transfer of power, to pressure Mike Pence with words, but that's conduct. To use fake electors, that's conduct. And so for them to say, we don't see the conduct in the indictment is ridiculous. And no federal court or appellate court, even up to the Supreme Court, worth its salt, is going to agree with that analysis. I thought the most revealing, transparent argument that they're raising and request for this new discovery is right on it's obvious. I did a hot take on this one, so did you. It's obvious that they're manipulating, of course, Mike Lee, the Speaker of the House. The only way he got elected is because he told the MAGA right wing that he would definitely release the Jan 6 footage, 44,000 hours. It's important that the American people see it independently so they can cherry pick and they can, Mike Johnson, I said Mike Lee, for the Speaker of the House, so they can cherry pick what they want. You know, those little interstitial moments when the people weren't doing bad things, or somebody was opening the door for them. Why don't they show all the bloody attacks with the sticks and the weapons and the flagpoles and the batons and the police shields that led to 5 people dying overall during this carnage? They don't want to show that. But that was the 1-2 punch. The next was after he released it. Then Donald Trump said, I want to know about every undercover agent that may have been within 5 miles of Jan 6. Right. So the CIA, the FBI, and the police department is going to reveal all their undercover agents, because there was this working theory, conspiracy theory, that was promoted by people like Marjorie Taylor Greene, that there were working officers of the FBI and other agencies that was really running the show. It was an insider job. It was a false flag, Jan 6th, and she put it on her social media. And then a senator repeated it. Said, "Look at that! That guy's holding a badge." No, first of all, he was an air conditioning repairman that was holding a vape pen that the sun glinted off of. That wasn't a badge. And the FBI field office director already testified in front of one of their kangaroo court MAGA hearings in the House in the summer that while there were former informants for the FBI for violent crime and drugs that happened to be among the couple of thousand that attacked the Capitol, or that they were there on their own. They weren't there they were there because they have the First Amendment right, at least to the point where they attacked the Capitol, to be down there. So, but there's 57 categories of information Donald Trump wants. Here's something I learned, because it never came up at all, because Donald Trump never said this ever to anyone during the attempt to cling to power, that he's now the protector of the sanctity of the election system from foreign interference by Russia, Cuba, Venezuela, and China. Okay, when did he ever make a phone call that was recorded or reported where he told the person, "I'm just trying to get to the bottom of foreign interference"? There was no foreign interference in 2016, because the Mueller report is BS, and I certainly wasn't benefited from foreign interference in 2016. But in 2020, there was tremendous amount of foreign interference, and I'm just trying to get to the bottom of it, and I have the right to do that. The problem with that is there's not one contemporaneous piece of evidence that supports that now new theory that he's allowed to argue that he was just trying to defend democracy from Chinese and Cuban and Venezuelan interference. I mean, it's like a page out of the Sidney Powell crazy playbook that they're running again. And this judge, Ben, has already said, "I don't really like when you use unsubstantiated attacks like the Biden administration and Joe Biden is behind the prosecution of Donald Trump," citing some sort of BS New York Times article that's not true. And she said, "That's unsubstantiated. You keep saying that." And rather than substantiate it, they push back and say, "The Department of Justice should prove it's not true." That's not how that works. Okay. You can't prove something that's not true that way. All right. Prove it's not true. Give us every bit of evidence that shows that Donald Trump is not being prosecuted by his leading, opponent who's controlling the entire operation. Look, to anybody that's out there that's really open-minded and listening, the Merrick Garland didn't even want to initially prosecute and investigate Donald Trump until the evidence was so overwhelming that he decided to, and he announced that he was running for office, that he decided to appoint a special counsel. Joe Biden had absolutely no role or control or input in the decision by Merrick Garland. Sure, was Joe Biden frustrated that Merrick Garland wasn't moving quick enough along with the rest of America? Yes. Was he able to coerce Merrick Garland into doing it? No, because if he was going to coerce him, by the way, he would have coerced him a lot earlier than when Merrick Garland got around to appointing Jack Smith, leaving him only 10 months on the clock to get an indictment out the door in time to have it be impactful before the election. If that's the grand conspiracy of Joe Biden, and by the way, I thought in that world that I just mentioned, Joe Biden is incompetent and senile. If Joe Biden is incompetent and senile, then how does he have, how is he suddenly the master strategist to use the Department of Justice to go after Donald Trump? Which is it, man? Pick a side.
Well, that's their thing with everything. It's contradictory. It makes no sense at all. Donald Trump is the greatest business person ever, and all of the valuations were right, but it is also the fault of the accountants who screwed it up, and they were the ones who I thought it was right. What are you talking about? And they go, President Biden doesn't know what he's doing, but he is a mastermind who has allowed all of this to happen, even state courts. He's somehow figured out a way to do that. And it's like, all right, when you realize it's just all a bunch of BS. But, what Trump and the MAGA movement relies on is fear. And that ultimately, whether it's the voters, whether it's politicians, whether it's companies, companies and editors, they're like, well, if if we say that about him, he's going to put out a mean post and then we're going to get the death threats. And so why don't we just avoid that? Like, let's just do another story on how President Biden is wearing new sneakers and how somehow that shows that he's old, and let's go after him, because Biden's not going to go after us. So let's do the negative Biden story, and let's not do the Trump story about calling people vermin and echoing Adolf Hitler. It's just a headache if we have to deal with it. Also, judges too, and I gave you my opinion on the last Legal AF that I thought that the judge in Colorado made a ruling of, yes, Donald Trump engaged in insurrection, but no, he's not an officer, even though we've talked about the 14th Amendment, Section 3, and the fact that Donald Trump, you did a great hot take on this, Popok, in prior briefing, claimed he is an officer when he was trying to remove a case to federal court. So Trump's saying that he's an officer, yet the judge in Colorado said not an officer, so therefore former presidents or people seeking the presidency, they can engage in insurrection and try to overthrow the government and they won't be disqualified. But if you're a senator and you're a member of Congress or an elector, then you can be disqualified. It makes absolutely no sense. But the petitioners in that case filed an incredible appeal brief. And look, I don't know what the Colorado Supreme Court's ultimately going to do, but I can tell you that I thought this briefing was one of the most kind of powerful, well-written takes on the 14th Amendment, Section 3. And it was just so very clearly written. Popok, I know you did a hot take on it. You want to tell us what went down in that briefing?
Yeah, I did. I was really impressed by the writing. And you know who was also really impressed by the writing? Somebody who's on the Mount Rushmore of the Federalist Society judges, Judge Luttig, who came out, and I did a hot take on this, who said it was the most eloquent, efficient piece of writing, right on the money, with the proper analysis of the 14th Amendment, third section, and mapping it onto Donald Trump's conduct he's ever seen. And because he's been very critical that lawyers and judges, including Judge Wallace in Colorado, sort of were struggling with concepts they shouldn't be struggling with. Firstly, that the 14th Amendment, Section 3, which was passed during the Reconstruction period in America as to be a loyalty test to bring people who left the Union, who left positions like senators and congresspeople and went over to the Confederacy, like Jefferson Davis, who became the president of the Confederacy, who had once sworn an oath to support or defend, preserve, protect, whatever you want to call it, to all support the Constitution. If they're going to come back, as I said on a hot take, it's like there was a bouncer now at the door and you weren't getting back into the club unless you either took an oath of office, or if you already had done these bad things where you had violated through insurrection or rebellion your oath to defend the Constitution, then you're going to have your disqualification or your disability removed by Congress. This is all self-actuating. And that was driving Luttig crazy, that and the fact that people were arguing that the rebellion and insurrection had to be against the government of the United States. That's not what it says. It's the Constitution is what you're rebelling or insurrecting about. Meaning, Donald Trump is not being tagged for being an insurrectionist or rebellious president because of what he did on Jan 6th in the attack on the Capitol. It's that he refused the peaceful transfer of power as provided for in the Constitution through his actions in his pressure campaign against Mike Pence, the use of the fake electors, and all the other things. That is the rub. That is the rebellion or insurrectionist activity. And who knows better than that than Michael Luttig, who's now a historical figure because he was the former judge consulted by Mike Pence about to give him the steel rod up his backside to make sure that he didn't do Trump's bidding and didn't recognize the Trump fake electors instead of the Biden real electors. So he wouldn't be sitting here talking about some sort of Donald Trump with Biden fighting to get back into the seat that he was elected to through a court process. That could have happened, but that's because Michael Luttig also then. And for those that think, oh, he's just like some old-timey guy, most of the justices on the Supreme Court, including one on the, and on other courts, including, unfortunately, we're going to talk when we get to the Voting Rights Act in the Eighth Circuit, the judge who wrote the opinion as a former Luttig clerk. Many of them on the Supreme Court are Luttig clerks or trace their heritage or lineage back to him on the Federalist Society. So for him to say that the crew the group that's brought the appeal to the Colorado Supreme Court on one issue. There's only one issue left for the Colorado Supreme Court, right? And it's 7 members. One does an insurrectionist president, because that's what they now are able to call Donald Trump based on the decision at the trial court level. Does an insurrectionist president get to be on the ballot again because the 14th Amendment, third section doesn't apply to an insurrectionist president? Yes or no? And just to give a little bit of info here, there are 7 members of the Colorado Supreme Court. 6.5 of them were put on there by Democrat governors. The only one that's the half is the Chief Justice, Boatwright, was first nominated for a lower position by a Republican, but when it came time for the Supreme Court, it was a Democrat. So you got 7 Democrats on the Colorado Supreme Court. Based on this briefing and their really proper analysis, I'll just say one. I'll give one example of where Judge Wallace got so many things right in how she handled it at the trial level, but this one she got wrong. For her to make her decision that the 14th Amendment, third section did not apply to a president, she said she went back to an earlier draft in the 1860s of the 14th Amendment, third section, and said in the earlier draft, there was a reference to the president by name that it applied. And in the subsequent draft that was passed, the name of the president, the title of president and vice president were removed. And therefore, she then concluded that that's an example that it shouldn't apply to the president. Wrong. The earlier draft had a narrow catch-all provision of all federal officers who also support the Constitution. That version was very narrow because they were listing it like a statute, like they were getting very specific in the draft. The president, the vice president, the electors, the this or that, and it had a very narrow catch-all. When they passed the 14th Amendment, they eliminated the laundry list of positions of federal office by name, but they broadened the catch-all provision to include any federal officer who takes an oath concerning the Constitution. You can call it support, you can call it protect, preserve, or defend, but it's your relationship with the Constitution has to be such that you swore an oath to support it. And so that captured the presidency as a position. How do I know that? Because there is legislative history and debate where one of the senators asked another senator as part of the legislative process, would this allow Jefferson Davis or the president who is an insurrectionist to be, I think there's a mistake here. And the response by another senator was, look at the catch-all language that would apply to an insurrectionist president. And the response to him was, I think I'm mistaken. You're right. Thank you very much for that clarification. Judge Wallace skips all of that. And that's the problem with her legislative analysis, which is hard. I'll give her some credit. It's hard to do legislative analysis, especially when you're going back to the 1800s. But it has to be done, and the brief does it properly for the petitioners. And we'll watch to see the new brief that comes in. The full Supreme Court's going to rule on this at the Colorado level, and if Donald Trump doesn't like it, it'll go over to the U.S. Supreme Court. It may make a pit stop with Gorsuch, who is the judge over Colorado federal things, or it might take a direct route directly to the U.S. Supreme Court. This all has to happen before November, Ben, or way before November, in order for it to impact the ballots. What did you?
I think it'll move fairly quickly after we get a ruling by the Colorado Supreme Court. It's possible Gorsuch stays it and basically says that using the Purcell principle concept that they made up, basically delay things until after an election, that they don't want to hear it, or they can hear it on an emergency basis, and they may hear it on an emergency basis. I think they should hear it. I think it needs to be resolved. But we know with the Supreme Court, instead of resolving things, they're seeing more into breaking things. And I think that's a segue into our topic on the Civil Rights Act of 1965 and how the Supreme Court and right-wing courts and the Court of Appeals have worked to gut it. One thing I want to talk about this as we talk about this horrific decision by the Eighth Circuit Court of Appeals and its implications, just talk quickly about the Voting Rights Act of 1965. It was passed during the Civil Rights Movement. It was signed into law by President Lyndon B. Johnson, and it sought to secure the right to vote for racial minorities throughout the country, especially in the South. It's been amended, I think, 4 or 5 times, expanding its protections. It was a bipartisan legislation when our government worked and we didn't have MAGA Republicans just trying to blow everything up. I mean, just think about it right now. We got a situation where MAGA Republicans barely can pass a continuing resolution and want to attempted to put America into default. And every time it's like the most basic task of, hey, can you pass like legislation just to fund the government, like the floor, the bare minimum task? Just think about this right here. In the House of Representatives, the Civil Rights Act of 1965 was approved by a vote of 328 to 74. There were 217 Democrats and 54 Republicans who joined. In the Senate, it passed 79 to 18 with Democrats, 49 Democrats, and Republicans, 30. Democrats. Just want you to think about that. Oh, let me just revise the House of Representatives. It was 217 Democrats for, 54 against, 111, sorry about that, 111 Republicans joined Democrats, so more than 54. It's as bipartisan of a piece of legislation that you can get. So you think about that was able to be accomplished in 1965. And one of the most kind of potent tools of the Civil Rights Act was something called pre-clearance, where when state legislatures would engage in these racist gerrymandering, our Congress, our federal government recognized that you have to deal with that, and there has to be mechanisms to stop that. So they actually created 2 mechanisms, double protection, if you will, against state legislatures, specifically those in the South, doing racist gerrymandered maps to disenfranchise minorities, specifically Black voters. And the main potent tool that was in the Civil and the Voting Rights Act of 1965 was something called pre-clearance in Section 5, where a 3-judge federal court panel or the Department of Justice would have to approve the state legislature's map to ensure that the maps were not racist gerrymandering. And then once they were approved, they could take effect. But then that was gutted. And how was it gutted? Remember, this stuff doesn't just happen overnight. So in 2013, there was a case known as the Shelby County decision. And in the Shelby decision of 2013, they ruled that the pre-clearance formula in Section 4 was itself racist. And it's part of that argument that it was racist against white people, is what they were saying, by trying to stop racism. That's an oversimplified view of it, but that's basically what they ruled. So they said the formula is gone. So if you eliminate the formula for pre-clearance, you then can't have pre-clearance. So it was a way for the Supreme Court, a right-wing Supreme Court in 2013, to get rid of pre-clearance by not getting rid of pre-clearance, but by getting rid of the formula. So then the only tool, as we had an updated census, and now all of these states are now, with the new census, are now gerrymandering their maps based on the new census, which was done during COVID. The only tool is a private cause of action, a private citizen or a civil rights group suing. The problem with that, though, and we've seen it over and over again, is that takes a lot of time. The burden is on a private citizen or organization to now challenge the state legislature's racist map, which our Congress back in 1965 recognized. Here's what the legislatures are going to do. If you leave the Alabama state legislature, they're going to carve up that state and disenfranchise Black voters by giving them no congressional district, or maybe one where the African American population merits 2 or potentially even 3 congressional districts. Our Congress knew in 1965 this would happen. And then when there would be a private lawsuit that now have been filed by these civil rights groups, what happens? They take a long time. And as they get close to an election, the Supreme Court has invented this doctrine called the Purcell principle. They just make these things up, basically. And under the Purcell principle, the Supreme Court goes, you know what? We're too close to an election. We've got to let the map by the legislature stay in place, even if they eventually say, wow, this is a blatantly racist map. So what happens in the elections is, then you have elections with the racist, unconstitutional, gerrymandered map because the Supreme Court says, let that happen. And then you have people who are elected. That was the tipping point of the midterm elections. The only reason why MAGA Republicans took the House was because of the gerrymandered districts that have since been held to become, that has since been unconstitutional. And then even when the private organizations succeed in their lawsuit, like we saw in Alabama, what happens, then the state legislature doesn't even acknowledge what the Supreme Court does. So then a district court has to appoint a cartographer to go make the map, and that takes time. And if you get close to the election, then the Supreme Court said, well, we must probably have to keep it in place. That's what the MAGA Republicans rely on, because preclearance was killed based on the formula being determined to be unconstitutional in 2013. So now you have this, remember I said there was double protection. Number one, preclearance. And then even if the preclearance didn't work, then you'd have a private cause of action where civil rights groups can bring lawsuits. So now after preclearance has been eliminated, what is the right-wing courts challenging? The private cause of action, and saying, actually, there is no private cause of action. And this was what the Eighth Circuit Court of Appeals just ruled. This is a ruling. There was 3 right-wing judges on this panel. There was 1 Trump, 2 George W. Bush. One of the George W. Bush judges was in the dissent. And this is what the ruling held. It was on Monday. The Eighth Circuit Court of Appeals, whose rulings apply to Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota, said the following. For much of the last half century, courts have assumed that Section 2 is privately enforceable. A deeper look has revealed that this assumption rests on flimsy footing, is what they said. And then the judge in dissent, Judge Smith, who's a George W. Bush appointee, it was a 2-1 decision, says, until the Supreme Court rules or Congress amends the statute, I would follow the existing precedent that permits citizens to seek a judicial remedy. So, Popok, you see how they, again, I wanted to give the history of the Voting Rights Act of 1965 so people know how far we've regressed. Because in 1965, the House and the Senate came together. They understood it. And now you have a situation where the House can't even pass a spending bill under these MAGA Republicans, and the right wing's doing everything to undermine the rights that were held to be like so obvious. So they gut preclearance, then they try to gut the private cause of action. So if you gut both of those things, in essence, what the right wing courts are saying is that actually, you see, the Civil Rights Act signed into law by Lyndon Johnson, the Voting Rights Act signed into law by Lyndon Johnson during the Civil Rights Movement. You see, it was just a pronouncement. It was just a lofty ambition. There's no ways to actually enforce this thing. It was just aspirational declaration, and it's like, you know, and that's why everything. And I wanted to, again, give the history because it's all gaslighting. It's all about raw power for these MAGA Republicans. And they'll come up with the sociopathic kind of frameworks, small government, originalist, textualist, conservative. But at the end of the day, it's all BS. It's power. They want to gut anything that actually reflects an equal playing field. And we see it here.
Well, you got, by the way, people should apply for credit because that was a masterful presentation of the Voting Rights Act and the Civil Rights Act and everything that Lyndon Johnson and those from that era worked so hard to put in place that have been piece by piece disassembled before our very eyes. But we have 2 things going on here. We got an open rebellion of MAGA right wing and primarily courts and appellate courts in the South who are rebelling even against this right-wing Supreme Court and their own pronouncements. So we got that going on. And when you have open rebellion among the federal courts who aren't respecting their bosses in the Supreme Court, that's a big problem. It's a big problem under our system of government, under our three-branch system, and the role of the Supreme Court in being the ultimate lawgiver of the land. So I want to talk about that too. What we're seeing and the why we're seeing it now. Some people might be thinking, why are there so many map cases that are being up in front of these appellate panels and ultimately the Supreme Court? I don't remember a period where there were so many of these map cases where the maps are disenfranchising black and brown people. At least that's the argument, in violation of the Voting Rights Act. And you and I, at the beginning of the year, the beginning of 2023, posited this question: is the Voting Rights Act, and particularly Section 2, on life support or not? Because it had been so chipped away by prior Supreme Court precedent that we really questioned whether, as you said, it was anything more than aspirational at this point. Good news was, over the summer, we had the ruling in the Allen versus Milligan case that seemed to breathe new life, led by John Roberts and even by Brett Kavanaugh, into the Section 2. The ability of a civil rights group or somebody that's a voter to sue under Section 2, have standing to go to court to sue under Section 2, and argue that a voting map is racist in violation of Section 2. And in Alabama, the Supreme Court, in a 5-4 decision in that case, said Section 2 is fine. They also implicitly acknowledged that civil rights groups, the NAACP and other civil rights organizations, can bring the case in their name to challenge because of the type of case that it is. It doesn't have to be just the Department of Justice or the federal government, which depends on who happens to be the president. Because the thing that we haven't talked about here is, if the Eighth Circuit is right, and they're not, and I believe the Supreme Court will rule that they're not, that despite 50 years of precedent, and the U.S. Supreme Court just this past summer acknowledging that civil rights groups can bring the case on behalf on the issue and not have to wait around for the Department of Justice to do it or the federal government, if they are right and Trump or somebody like him gets back into power, they will dismantle the Civil Rights Division of the Department of Justice, and there will be no cases brought. The Department of Justice and the feds will be blind to violations of the Civil Rights Act because of who's in power in the White House. That's what happens. Even when a Trump is in office, the NAACP, the Southern Poverty Group, crew can bring lawsuits to challenge and then take their chances at the federal court, appellate court, and Supreme Court level, but not under the new thinking, the new teaching of the Eighth Circuit. Eighth Circuit, yes, it's a 3-judge panel, but it is binding law now for the states that you just identified, has just said, thumbed their nose at the U.S. Supreme Court, which I think is going to get them into trouble. We'll talk about that in a minute, and has said, NAACP can't bring a case under the Section 2. What about the dozens and dozens and dozens of cases that say they can, including the Supreme Court in the Alabama decision this summer? No, ignore those. They can't do that. We never get to the merits because they don't have the standing to bring the case. And what that is a signal. When you hear that, that means we want the executive branch, whoever's sitting in the president's seat, to have the ultimate power through his Department of Justice to decide which, meaning none, violations of Section 2 he'll go after, or she'll go after, and not any old group that just comes along and wants to argue that the Section 2 has been violated. This is the open rebellion I'm talking about. We've seen it over and over again. We've seen Mississippi thumb its nose at the Supreme Court and said, oh, you told us we had to have a map with an extra black district? Well, F you, we're not doing that. And then the Supreme Court has to say, check your paycheck. You're part of us. We're your boss. You do this. We're not going to allow open rebellion. Even this Supreme Court, even Clarence Thomas in Alito said that's probably a bad thing when federal courts don't file follow Supreme Court precedent. And they just did it again on the Eighth Circuit, because the Alabama decision, if it stands for anything, it's that a civil rights group has standing to bring a case under Section 2, exactly contrary to what the Eighth Circuit just came up with. Now, Strass is an interesting cat as the person who wrote the decision in the Eighth Circuit. He came out of Minnesota. He's practicing in his religion. He's very religious. He's the first openly, I forget. I think he's Jewish. Whatever his religion is, he's a practicing Orthodox Jew, and he's a Trumper. And he wrote the decision, and he got one other person, Gruender, to go along with him. And the only person who didn't is, yes, a Bush appointee, but also the only African-American that's sitting, or at least on that panel. And so Smith said, yeah, I don't think that's the right thing to do here. Now, the question is, does the organization that lost, the NAACP, do they go for a full en banc ruling by the Eighth Circuit, meaning all the judges of the Eighth Circuit, or do they just take this obviously wrong decision and take it up to the Supreme Court? Now, the interesting little twist here is the Eighth Circuit, with all the states that you identified, is the Supreme Court justice that's responsible for the Eighth Circuit is Kavanaugh. Kavanaugh just joined with Roberts and the three liberal members of the Supreme Court on the Alabama case. So this is the raw. I mean, Kavanaugh should instantly let this case that's on appeal go straight through to the U.S. Supreme Court. And then it's going to be up. You know, we know that Clarence Thomas has been itching to get rid of the Voting Rights Act in Section 2, of all people. He's itching to get rid of it. He's already said, and Kavanaugh said in his concurring opinion in the summer in the Alabama case, that he doesn't think that the Section 2 to allow map supervision by the Supreme Court should go on forever. Time should take care of racism. Apparently, that's what happens in the Supreme Court world. Time solves and heals racism. Although that's not what we're watching in the streets and in society and any place else. But in the Supreme Court world, that you just the clock just has to go around more. And then all racism, we won't need any of these protections. And to answer my posit at the beginning, the reason we're seeing so many map cases right now is what you taught our audience about preclearance. Preclearance has now been removed in all of these states. These are the first maps off the first censuses that have happened since preclearance has been removed. So no more three federal judges babysitting Mississippi and Alabama and the rest of them. This is their first shot without training wheels, without constitutional oversight by a federal judge panel to do it right, and they do it wrong because their natural instincts is to screw the black and brown and disenfranchised person in their state. There's a reason that the state maps don't match the demographics of the state. 27%, 30% black. Why are the districts representing 12% black? Because the whites that are still in power, almost like apartheid, don't want to give power to the people in the state that deserve it and have earned it on the most fundamental right that you have under the Constitution, that even our founding fathers recognize, is the right to vote and not be disenfranchised. And that's the thing that the southern states are like, nope, we're going to we don't know more preclearance? Okay, give me a map that's all white. That is what I want. And then you get judges in these districts that say, yep, looks good to me. And if it's not good, let a president and the Department of Justice deal with it, hopefully Republican and not Democrat. I think the Supreme Court, when this finally gets there, is going to declare once and for all, as if it wasn't already precedent, that civil rights groups and others not named the Department of Justice or the United States of America have the right to bring cases under the Section 2 of the Voting Rights Act to call out disenfranchisement and racism in voting among these states. Because if you, like you said, if you eliminate both, if you get rid of preclearance and you don't allow people to sue under Section 2 and you wait around for the federal government and it's in the wrong hands, you will never see it and people will be disenfranchised forevermore.
And our Congress understood that in 1965. Think about that. Don't we want to progress as a society, expand voting rights, help people more, we've come to a place where the opposite is happening, and it's not a both sides issue, folks. And that's why just want to give you the data, the history of it. I guess all of those Republicans who joined Democrats in 1965, I guess all of them were rhinos and deep state operative. No, it's just the change in the landscape right now in terms of what this MAGA movement has done is, I'll let you all decide for yourself, but I think it's ever present. And so I want to thank everybody for watching this episode. We hope everybody had a wonderful Thanksgiving. We will keep you up to date on all of the breaking news, all of the legal cases. We will make sure that you're kept on up to date on all of the developments. Make sure this is a great way that you can help us out here on LegalAF, and this is free. It's free. If you can go right now, subscribe to the LegalAF audio podcast. Wherever podcasts are available, just search LegalAF, hit subscribe. Make sure you're subscribed for free on your audio podcast and leave a 5-star review. It may take you 30 seconds to do it. You've been watching this episode for over an hour and 40 minutes. So if you could just do that for 30 seconds, it helps the show massively. So thank you for doing that. Check out store.meidastouch.com for all the best pro-democracy merch. Check that out. There it is, 100% union made, 100% made in the USA. Don't worry about the AF. It's not a curse word. It stands for Analysis Friends. Legal Analysis Friends. That's the AF, for those wondering. Hit subscribe. We're on our way to 2 million subscribers. Popok, I'm thankful for you. I'm thankful for this unapologetically pro-democracy community that all of you watching and listening created. Thank you. It's such an honor for myself, Michael Popok, Karen Friedman-Agnifilo, and our whole team here at the Meidas Touch Network to be a part of this community that you all created. Thank you so much. We're in this together. We will keep you updated, and we will keep supporting our democracy each and every day. Have a great one, and shout out to the Meidas Mighty.